everybody, and welcome back to the Legal Weekly Wine, where we talk about the week's hottest legal topics. It is the last week of 2023, and we are going to wrap up some of the Trump cases. So we've got updates on the Jack Smith case, the D.C. case, as to the rejection by the U.S. Supreme Court of at least a preliminary hearing. We've got his motion in front of the district court. And then we have an update on the Colorado case and the Michigan case in terms of the 14th Amendment and the disqualification, as well as, let's make sure I've got this all right, Christmas statements by Trump. We're going to throw that in for fun. And a little bit about the Iowa caucuses to end out the year. Welcome, everybody. I'm Virginia Tehrani. I'm with Tehrani Law, LLC, because you never need a lawyer till you do.
Yeah, you do.
And with me, I have Dr. John Weil, the Dean of the Honors College for Middle Tennessee State University, who is an expert on the Constitution, the amending process, and constitutional law. Welcome back.
Glad to be here. Happy New Year, almost.
Yes, Happy New Year to you. And I know you have a special tie for us, so we've got to take a look at that.
Oh, yes. I rarely wear cartoon ties, but Cat in the Hat somehow seemed appropriate. Maybe for the entire year. I don't know. but,
Maybe.
But it looks fairly cheerful. That's Trump. Wishing everyone holiday greetings.
Yes. Okay. So we have to take that up first. We heard a message of peace, goodwill toward men, right?
And rotting in hell, yes.
I was like, oh my goodness. You know, a little bit of holiday cheer.
You know what it reminds me of? One of the lesser known facts about the Bible, which I've written about, if you know.
Yes.
Are so-called, and I may be mispronouncing it, but imprecatory psalms, which are psalms where the psalmist, often David, sort of curses his enemies. In one case, they wish that the baby's heads would be hit up against the stones, you know.
Oh, goodness.
It's, you know, he just pours his soul out to God. Why is everybody against me? I wish you'd go after him, whatever. Now, in fairness, often it seems unlikely that he carried out these. He's just being very honest with God. But it sounds like the kind of thing that he might say in passing, you know, may all my enemies rot in hell. As I lead Jerusalem.
Oh goodness!
But it was one of the more unusual holiday greetings that I had seen.
It was. Now, I mean, I know there's the question of is it rot in hell or is it burn? But you know, either one.
You do wonder. Do you think was this Christmas morning? Do you think he woke up and ran down to get the present? You know, opened the stockings and there was coal in them.
Maybe.
You know, there was a piece of coal from Jack Smith, and then there was another piece of coal by Carol, and then there's another piece of coal by the election officials in Georgia.
Oh my goodness, right?
I think maybe that just set him off a bit. That would be discouraging, you know, especially to be a billionaire and then find coal in your stockings.
Yes, very much so. Joy to the world.
Yeah, joy to the world, right? And peace on earth.
Goodwill toward men.
Once we get rid of all the people who are going to rot in hell, it'll be very peaceful.
Yes, very, very peaceful. So yes, you know, and that leads us, we always have to tie it into something legal, and I'm going to tie it into our First Amendment, the freedom of speech. He does have, as unsavory as his comments may be, he does have the right to say them, and many people agree with him.
And you know, he's not the first. One of my, I don't know why, but one of my favorite politicians to read about is a guy named John Randolph, not to be confused with Edmund Randolph at the Constitutional Convention, but this was a guy who was known as a very tall figure, beardless, it turns out, which a lot of people made fun of. He would often carry a whip, and he would bring dogs into Congress. And he was known for skewering opponents.
With the word, right? Not.
Yeah,
no,
yes.
Okay.
with language that was often racist or
Oh,
commented on their
goodness.
masculinity or whatever.
Oh, my
But
goodness.
what's fascinating is, well, one of the fascinating things is that he ultimately turned against slavery, which is highly unusual for a Virginia plantation owner. But the other thing was that he took a trip to England, and they all followed him around like puppy dogs because he was such a colorful figure. He reminded them, I think, sometimes of maybe some of the English aristocracy, and it's like, okay, they had this in America too.
Oh, that's funny.
But I don't know, instead of this might actually be better. The allegation, which I have no idea whether it's true or not, is that Trump has someone gave him the speeches of Adolf Hitler, which are by his bedside, along with the Bible reading every night, reading that and the Art of Success. Okay, I'm off. I just got off topic here. Oh,
Oh, it seemed like it was headed in a great
right.
direction.
You're right. It was. It's in maybe instead of reading the speeches of Adolf Hitler, he should read the speeches of John Randolph. It
Ah,
might provide further
more
invective.
colorful language.
Yes, further invectives that he might be able to use throughout the new year. But I guess all of us have felt that way at times, right?
Absolutely.
Uh, that's the danger maybe of being a public figure. Is you say something and next thing you know, it's like, well, that wasn't very nice.
True, true. Yes, but yeah, with Israel and Ukraine and everywhere else, it just seems like a little bit of peace would have been
I think peace and goodwill would
a
be
better comforting, more
probably so.
hopeful message for the Christmas time.
Yes.
Okay, so let's talk about another First Amendment issue.
Okay.
You and I have been following, clearly been following all of the Trump cases this year because as much as I would love to cover other things, and we have, he keeps popping up in the legal news,
Okay.
not just the political news. And especially this year, we've dealt a lot with the First Amendment. What does he have the right to say? When does he have the right to say it? Where does he have the right to say it? And just at the end, for the end of this year, I gotta love it as an attorney. For all of these motions being filed at the end, Jack Smith just filed a doozy of one.
Okay.
He filed a motion in limine for the DC criminal case against
Okay. Now
Trump.
you and I know, but I had to relook it up just to make sure. Tell us what in limine means.
That is a good question. I know the practical terms for it. I don't know if I actually know the Latin meaning. But technically, practically how it works is that it's a pretrial motion where you bring it before the court before the jury is seated, before the trial is actually begun, to say, I want this excluded before trial, so there's no risk of it coming during trial where it would improperly prejudice the jury. Whether it's evidence that should be excluded by hearsay, by speculation,
Illegal
if it's
search
known.
and seizure, right?
Definitely so. Fourth and Fifth Amendment violations, Sixth Amendment violations, so search and seizure, right to counsel. Those violations would absolutely be motions in limine, motions to suppress, but motions brought before the trial to find out what's going to be excluded.
And by and large, it's not a clear distinction always, but these are matters of law rather than matters of fact.
Absolutely.
Right. Yeah. So the judge there's certain matters that the judge has to decide as to what's legally admissible or not.
Exactly.
Then, given those facts that are permitted to enter, then the juries are supposed to make their judgment based on the facts rather than hearsay or speculation or anything else.
Yes, exactly. So what we're getting in this motion, this is one of the pretrial motions that Jack Smith has just filed, and he's trying to prevent, in my opinion, he's trying to prevent the show that happened through the New York fraud trial. where Trump got on this, stand at even just the limited portion that he was called regarding the contempt issue, and outside of the courtroom and through the attorneys, where they continued to make it almost a political statement,
Right.
to say, this is happening to me. They're vindictive. This is the Biden administration going on, where Jack Smith is saying, look, this has no place in a courtroom with a jury. For a judge trial, and what is often actually praised to the judge in the New York case. There are many things that have not been praised about him and the way that his case has gone. But in one praise, it has been, well, he's just let a lot of it go, is how they're phrasing it. He's let a lot of things into evidence that normally never would have gotten into evidence.
Because presumably as a judge, he can distinguish under the rules what's relevant and what's irrelevant.
Exactly.
In a way that a juror might not be able to do. Not because they're ignorant, but simply they don't know what the rules of evidence would be.
Right. And that's one of the reasons as an attorney, we're taught the rules of evidence, is because it's almost like speaking a foreign language. You cannot go into a courtroom and just say whatever you want to say by any witness or any defendant or victim. And if it's a civil case, it's not a platform to simply speak. But unlike just a First Amendment issue where you have the right to speak, this is limited. And it's limited by the federal rules of evidence in this case because it's a federal courtroom. And specifically, I think you and I have pinpointed several ones that come into play, especially relevancy, 401, 403, which is relevant evidence is curtailed by the risk of unfair prejudice. As well as some hearsay and speculation. So these are terms that attorneys are used to, where the public may say, look, let it all in, whatever Trump wants to say. And, this is a corrupt political process. He should be allowed to say whatever he wants. He should be allowed to say that this is vindictive, that everyone's out to get him and put in his theories. But what Jack Smith is saying is for this jury trial, like you said, Dr. Weil, for this jury trial, they are not familiar with the rules of evidence. And not that they're ignorant, not that they can't understand, but a jury is much more at risk for unfair prejudice. And I love the way that the rules broken down. But before we do that, I'd love to break down exactly what he is asking to be excluded from the court. Now, what can you remember?
Well, I mean, he's not well, let's be careful. Some of this evidence, it's not so much that he couldn't make the argument if he has an argument to make.
Yes.
It's that he cannot make unfounded assertions such as Jack Smith is in cahoots with Joe Biden.
Right.
There's no evidence of that. That the actions that took place on January the 6th were the result of foreign, they were generated by foreign actors, or that they were provoked by inside, by governmental agents.
Exactly.
Or one of the most fascinating, and the one that Smith has tremendous fun with, is the notion that some of the actions. Okay, help me out here again.
I know exactly which one because legally,
I know you do because why can't I?
I got so excited. Not who cares one way or the other which way it goes for me, but the language was exciting, and it was a very clever argument where he's saying, okay, they should not be allowed to say that this was the result of a failure of law enforcement.
Right.
This is the result of Mayor Muriel Bowser's actions, that he shouldn't be allowed to claim either of those things in court. And we have to get his statement. It's hilarious. And honestly, I have to agree with him because he said a bank robber cannot defend himself by blaming the bank security guard for failing to stop him. A fraud defendant cannot claim to the jury that the victim should have known better than to fall for his scheme, and the defendant cannot argue that the law enforcement should have prevented the violence he caused and obstruction he intended. Very clever arguments.
It is. Now again, that doesn't mean that he has yet successfully proved these himself.
Correct.
It's just as Trump and the defense has arguments or evidence, so does Jack Smith. So he, at this point, he has not proven that Trump incited the riot on January 6th. But if he does, he has to do it through evidence.
Yes.
Not through assertion. Not through, well, I heard on Fox News or wherever that foreign actors were involved, or I believe there were provocateurs in the crowd. If any of these things can be proved, they might go to mitigate some of the responsibility. But if you participated or you yourself have had a role in inciting, it's not going to exonerate you.
Right. And that's like a self-defense claim. A self-defense claim doesn't work if you provoked it. If
Right.
you started the fight, then you can't then claim self-defense.
And we had some good, we were talking a day or two ago, and we had some great examples about what you sometimes see in movies about the twin defense.
Oh, yes.
As a twin, I know you appreciate this, right?
I do.
If you're a defense attorney, you don't have any business saying, well, maybe it's somebody's twin if they're not, in fact, a twin. You would first have to have the evidence. You would have to have in evidence the fact that there is particularly an identical twin out there with the same motive, means, and opportunity as you would have.
Exactly. There has to be a modicum of truth.
And I know you have the advantage that I haven't had, which is you've actually been able to argue in a courtroom. And I know one of your favorite cases involved a case where, was it a police officer?
Yes.
Kept referring to an individual as what?
The victim. As
the victim, and evidence had not yet established that the person was a victim.
Exactly.
And so what was the result in that case?
So it was interesting.
I know you hate to talk about it.
Oh, I do. I hate to. Honestly, it was, and you've heard me say this before, it was probably the case of a lifetime for me. It happened within my first 3 years of practice, so everything was downhill from there. But
wait, don't yell that! Remember, you never need a lawyer.
I'm a great attorney.
You don't want one on the decline,
right? Just waiting for the next one. So normally it's not a problem for a police officer to come in and say in a prosecution the victim, right? If there's a homicide, there's clearly a victim. If there's a fraud, there's clearly a victim. But in this case, and I haven't done a lot of rape cases on the defense, honestly, I think this was the only one, and I truly believed the innocence of my individual, my defendant. But our claim was, okay, yes, there were sexual relations, but it wasn't, and a lot of people are like, oh, it's consent. Right? But this one, I truly believed it. And what the prosecution was doing was saying, oh, the victim. We spoke with the victim. And I made a motion in limine before court saying, look, we have to have it established that there was even a crime. And if it wasn't a crime, there's not a victim. So we can certainly say the witness, the individual, this person, she, her, whatever, word we want to use to describe her, one of the individuals involved in the incident. But by calling her a victim, we are prejudicing the jury for them to believe that there is a victim. Right. And maybe they can prove that there is one, but the jury should determine. And sure enough, the judge agreed and prevented that. There was a rule beforehand of tell all your witnesses. You cannot bring in any word of victim. You cannot say victim. And the detective in this case got on the stand and continued to use the word. And by the third time that he'd used it, the judge in front of the jury admonished him, very sternly of, you cannot use this word, and even used my argument. We have not determined. It is up for the jury to decide if she's a victim. Use that word one more time and there will be consequences. And sure enough, the fourth time it was used, the judge stood On the bench, he stood and he pointed and he said, "Get out of my courtroom. You have failed to obey a proper order of this court. Your entire testimony is stricken."
Well,
And it was gone. The entire thing. Who keeps out a detective's statements? And it was gone. We won the case. Ultimately, he was found not guilty of all charges. It was a monumental case, and there were so many other fun things with that case, evidentiary-wise. But it reminds me of this one for Jack Smith. He's saying, okay, before we even talk about a victim, let's,
let's take
this.
it a little bit farther then.
Yes.
So if Smith, and I don't know if Trump's had an occasion yet to respond to this. I mean, I know publicly he said he has a First Amendment right, and we've already discussed how we don't, you don't have a right. You have a right to make these allegations in a public forum, but you don't necessarily have the same right to present them in court.
Correct.
But let's say it does go to court. We don't know that Trump would take the stand, but let's say that he takes the stand and he does begin to say some of these. So what would the typical remedy would be for a judge to admonish the witness to stop and urge the jurors to exclude it?
Yeah, the first order of business is to do a limiting instruction to the jury, where they say, Mr. Witness, we have had a ruling that you can't say this. I'm asking you not to say this. And then they'll turn to the jury, ladies and gentlemen of the jury, this statement has been made. It is not supposed to be made. You're supposed to disregard it.
Right.
But in this case, I honestly don't know if we'd be able to get there, because what Jack Smith is arguing is that it is so prejudicial that if we hear of it at all, a limiting instruction may not be enough. Right. You may not be able to say to the jury, just disregard this, because it is so highly inflammatory and it is so political in nature that you may be relying on whether the person is an independent, a Republican, a Democrat, or, their likes or dislikes of public figures and political
figures. The voir dire
figures.
in these cases is going to be extraordinary. Voir dire is, as we know, it's a process of deciding who's going to be on the jury.
Yes.
And typically, during the selection process, attorneys can make unlimited objections for cause.
Yes.
You can't have Donald Trump's daughter there, or his wife, or a business associate. You can't have someone who is given speeches for or against Trump there.
Correct.
But you also have what are known as peremptory challenges, which are basically sort of based on hunches.
Yes.
They cannot be based on race. They cannot be, I don't believe they can be based
ethnicity.
On sex. Ethnicity.
Right. Yes, it depends. Definitely race and ethnicity. The gender is kind of iffy. Generally, it's not supposed to be. It's known as a Batson charge, as you can say that they're improperly being excluded based on race or other discriminatory
But otherwise,
factor.
they're basically based on hunches.
Correct.
And they may very well, I can see both sides attempting to make, Trump is going to try to get people that he thinks are MAGA people.
Yes.
And the prosecutor is going to want to avoid MAGA people, not necessarily anyone who's ever voted for Trump,
right?
But anyone who, just seems like the kind of person who would not weigh evidence fairly either for or against Trump. And, don't be surprised if the jury selection itself takes, weeks or days. And as you know, some of the arguments right now for, Mark Meadows' argument, as I understand it, for that he lost to have the Georgia case against him, the case for Georgia election, moved to D.C. was on the basis that he thought he would have a federal court, he thought he would have a better choice of jurors there than he might in the state of Georgia.
Yeah.
And it could work. It could work both ways.
It's going to be hard to find a fair and impartial jury. anywhere, but especially in D.C., it's going to be hard to find someone who doesn't have a strong political opinion regarding any of the characters. So you can say, okay, look, this isn't involving politics. This is involving the person and whether they committed a crime. But with Trump, it's so hard throughout the country to divorce your ideas of the person, of the politics, of the political party from what's happening, that it feels like it's an impossible journey to find any juror. You want somebody who's, been away in a foreign country and hasn't heard anything for the last 3 years.
Yeah, you wonder about, if someone literally has no opinion about Donald Trump, you wonder if they've ever cracked a newspaper.
Right.
Or listened to nightly news.
Right.
It would be hard not to have an opinion for or against, and maybe mixed emotions.
Exactly.
Based on.
So to find them, go ahead.
Well, what's fascinating about Trump from a political standpoint is you just think in the last couple decades, how many defeated candidates for president have remained in the limelight? There's more about Trump on the news than there is about Biden, and Biden happens to be the one who's president, even though Trump might want to deny it.
Right.
And so it's going to be hard to choose an unbiased jury.
It will be. And so once they get an unbiased or allegedly unbiased jury, as unbiased as possible, then the idea is, well, if they aren't biased yet, by even having Trump or another witness say these things, they would be making an unfair bias that can't be undone. And the monumental task of a mistrial and choosing another jury is crazy. But honestly, with the delay tactics that Trump's team has been taking, it would not surprise me if they just happen to mention something that's excluded. Whether, I'm not saying all of these things would be excluded, but if something were to be excluded, it wouldn't surprise me if it still comes in and, there's a mistrial. And I hate to be implying something improper.
But you think Trump's people would not be the ones who could ask for a mistrial in a case where they exceeded the limits, could they?
Well,
but Smith would have to decide.
Smith would have to do it. And in this case, it's not so much that I fear the attorneys themselves as to if Trump testifies, that honestly, that he's such a loose cannon in testimony that he may go off on this. And then it would have to be Jack Smith who says, okay, we're asking for a mistrial because these statements are in front of the jury. They weren't supposed to be. Now there's unfair prejudice. We can't walk this back. No limiting instruction that we could possibly give will have the jury disregard it. And there has to be some modicum of truth. So in my mind, what would have to, if Trump wants to say, so Jack Smith, and I'm backing it up so I can make sure we've said the exact words. So Jack Smith is asking that he be prevented from saying things about the prosecution being selective and vindictive, that it's been initiated or coordinated with the Biden administration, the poor law enforcement, violence stirred by what you were saying, foreign sources or provoked by undercover agents. And under Rule 401 for the rules of evidence, we have it has to be relevant. And Trump can say, look, it's whether I caused this or, actually committed a crime is based on, well, these other people did it, right? I didn't do it. These other people did. Well, it could be a solid defense. So I think they might be able to pass a strict basic relevancy argument. The question is Rule 403, which says that you cannot, even if it's relevant, you cannot admit it if it is unfairly prejudicial, if it is more prejudicial than probative. And the language of this rule, I like this because it says the court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one of more of the following. And in this case, it's not just unfair prejudice. So you've got unfair prejudice, you've got confusing the issues, misleading the jury wasting time or necessarily presenting cumulative evidence. But I think in this case, it's the issue of unfair prejudice, confusing the issues, or misleading the jury. And if Trump can't produce evidence to prove that there are foreign individuals who, interfered, or there were undercover agents, he can say, and Jack Smith is saying he can say it in the public, they have a right to believe or disbelieve him. But in court, there has to be this underlying modicum of truth. And it would not surprise me if there is an offer of proof or a request for an offer of proof where the judge says, okay, I agree with, Mr. Smith, where if these are not supported, then they shouldn't be allowed. You can't just make up the twin defense. If there is no twin, you shouldn't be asked about a twin. If there is no foreign influence, you should not be allowed to create an inference of a foreign influence. So it would behoove Trump's team, where of all of the times for him and Giuliani to be saying, we're going to prove, right? How many times have we heard that? There's going to be 100% proof.
Well, and in Giuliani's case, at the end of the trial, now he said this to the public rather than to the jury.
Right.
But at the end of the trial, he says, we didn't have a chance to put up our defense. He didn't take the stand, probably wisely. Right. But you can't not take the stand and then say, well, we weren't treated fairly because we didn't get a chance to speak.
Right. And he's like, I'll be exonerated with the truth, with the facts. Well, sorry about my dogs, but this would be the time, at least in a preliminary offer of proof before a judge prior to the court trial, by saying, okay, here's the evidence that we do have that would show foreign interference, that would prove undercover agents, that would show that this is selective and vindictive prosecution. And if the judge were to say, and it's called conditional relevance, that it could be permitted if there's enough evidence behind it. And if he can finally step forward with this allegation of truth and prove any of these defenses, at least to a judge legally beforehand, then the judge can say, okay, at least there's a modicum of truth.
Right. That would be relevant.
It would be relevant, and it's not necessarily unfairly prejudicial, because it appears that they would have this witness to prove this and another witness to prove this other fact. But if they're just grasping at straws, so to speak, if they're just making it up in hopes that someone will be convinced by it, well, let the public deal with that, but a jury shouldn't be.
Right. So, and I think one of the problems is, and this is true of both right and left, there are a lot of people in the United States who have all kinds of conspiracy theories about the government's out to get them, or, if we only knew, everything from UFO sightings to, you name it, there's a conspiracy theory out there.
Right.
And some of them, I guess some of them could ultimately be proven true. But in a court of law, you can't just advance a theory without, or you shouldn't be allowed to advance a theory without any evidence to back it up.
Right.
Let's talk a little bit about the appeal from the Colorado decision and the Michigan decisions, because I think they're both very important. Should we start with Colorado?
Yes, let's start with Colorado.
Because that's another, let's see, is this a Jack Smith motion or not?
No, it is not. So the Jack Smith motion was rejected, not rejected in terms of there was an opinion about it, but the Supreme Court refused to hear, to advance the case above and beyond the Court of Appeals.
This is the immunity case, right?
Correct.
So what happened is that the lower court, district court, or DC, I believe, right?
Yes.
Decided that Trump
was not immune.
Did not have immunity for criminal prosecution.
Correct.
For acts that he committed while in office. Now, Trump has subsequently filed a fairly repetitive, I don't know that he's advanced the case much beyond what it was prior to that, but he has since filed objection to this, just saying that no, anything within the outer perimeter of his office is immune.
While
Now,
he was in office,
right.
right.
Part of the question is, is it within the outer limits of the office? In the lower court, the argument that the government had made is they had tried to distinguish Trump's official acts from his campaign acts.
Correct.
In fact, in another case, Trump himself had argued that he had done things as a campaigner rather than as president, and now they're saying, well, you can't have it both ways.
Right.
But essentially, the district court ruled that he didn't have immunity. And Smith and Trump wanted to challenge this, and Smith wanted the U.S. Supreme Court to bypass the circuit court.
Correct. To jump over it.
Right. And sent an appeal to the Supreme Court, and the Supreme Court fairly summarily said, no, we're going to wait.
Right.
And in the favor of the Supreme Court, one might think that you would develop arguments a little bit further in if you had not just one court decision, not just a district court, but also had an appellate court. Now, what makes this dicey for Smith is he's aiming for a prosecution that begins in March, which would be maybe after the Republicans have already chosen their nominee, which may or may not be Trump, and certainly would be before the election. And Trump, of course, would hope that you would defer any of these decisions until, his argument is if he's at trial, then it's unfair because he won't be able to campaign.
Right.
And some believe, and it's hard to know, I think Trump has denied this, but if Trump is in office, he would almost surely claim at the least that he could not be imprisoned, maybe even fined while he is in office. It would detract from his job. And as we've talked about before, the Constitution is silent on the matter. I think as a matter of legal principle, a person should not be able to pardon themselves, but the Constitution doesn't prohibit a president from pardoning himself. So to some extent, you have a political and a legal thing happening here at once. If Trump can postpone any trials until after he becomes president, he would almost surely say it's not proper to adjudicate these while I'm dealing with dealing with matters of national and world importance.
Exactly.
And might even be, and then beyond that, he might be able to, he is the chief executive officer, he might be able to fire Jack Smith.
Right.
Or anyone else.
He is special counsel. He's specially designed.
One of the fascinating things about the whole political situation right now is that Trump basically has said that if he's in office, he's going to get vengeance.
Right.
He's going to act politically. And in the meantime, he's saying, essentially, everybody's acting politically against me, so I'm going to get back with them politically. Right. So he acts politically and then essentially says everybody else must be acting politically too, so this is unfair. So really, really fascinating kind of development. But now, as I understand it, the appellate court has set arguments for early January.
January 6th or 9th.
Right.
It's coming up.
And there are cases where a circuit court has turned a decision around within a week or two.
Right.
But it's probably far more common to take a month or two.
Correct.
And in the meantime, the trial aspects are suspended until this issue is resolved. And I guess that makes some sense. If the president if Trump is immune, then no reason for the trial to go forward.
Right. Let's not waste the time and the resources.
So then, of course, but let's say even that if the appellate court makes a quick decision, then it would still take a month or two or three or more to appeal it. Well, it wouldn't take long to appeal it. It can go back
to the Supreme Court.
But then you would have an occasion to go to the Supreme Court. But the Supreme Court could simply refuse to hear the case.
They don't
which
have
would
to take it.
which would leave whatever the circuit court opinion is in place.
Correct.
So we could end up with it, but this is such a consequential issue. Can a president be criminally tried for something that he did in office? And I think the answer is absolutely. I think the answer is no person is above the law, including and maybe especially a president
who's charged to enforce the law.
Right. We have to be especially wary of prosecution of illegal actions by a president. But that should be balanced against, we want some guidelines in place to prevent what Trump is saying is happening, political prosecutions. And this is what worries me. Now I'm going to wander just a little bit, but this is what worries me about and I don't know what they are even calling it right now, because it's not a formal, I guess it's a formal impeachment inquiry that the House of Representatives has brought against Biden. It appears to be based on, much like 403, there doesn't seem to be a lot of lots of evidence that Hunter Biden may have broken the law and whatever. But as far as I can tell, there's not evidence on the record yet that this has involved his father.
Right.
And it seems like it's a fishing expedition, which is basically motivated by the fact that largely Democrats twice impeached Trump. We're going to get back.
We're going to do it again.
Democrat.
Mm-hmm. And you did it to us. We'll do it to you.
Yeah. Mm-hmm. And impeachment really should be more a legal than a political issue. Impeachment should not be done on a whim. They should not be done because you disagree with the policies of a president. And, we know in early America, we didn't have an impeachment until almost 100 years after the Constitution. The 1860s, Andrew Johnson was the first president to be impeached. And then we went we would have impeached Nixon had he not resigned.
100 years later.
All the way to Clinton, you go another more than 100 years. And one of the fascinating things about the argument that Trump's attorneys have made in terms of presidential immunity in their latest brief is they say, clearly, a president wasn't intended to be prosecuted for things he did in office because we've never done it before.
Right.
If we went 200 years without ever indicting a president for past actions, this would suggest, according to Trump's attorneys, that it was never intended that this would be done. Now, the other explanation would be that we have never before had a president who engaged in illegal criminal activities while he was in office. And the one exception there might be Richard Nixon, who was given a retroactive pardon for anything that he may have done while in office. So we never really resolved the issue then. Although, in U.S. versus Nixon, we do have a case where the court has said that in any matters that involve criminal activity by a president or his subordinates, that grand jurors have a right to evidence.
Subpoena
and in this
the
case,
evidence.
It was to tape. So that precedent, although it didn't deal directly with criminal, whether Nixon was guilty of a criminal offense, it related to evidence gathering for possible criminal offenses.
And honestly, I like that example because the other thing that's very similar in this case to the Nixon case is it was related to campaign activities. Watergate was related to political campaigning.
Right. It was a break-in of his the offices but the criminal activities, it was also related to cover-up.
Correct, but it was ultimately based around campaign, political parties in the campaign. So actions that occurred because of the campaign and cover up of what was happening with the campaign. And we have a similar thing here as the allegations are this isn't so much his presidential activities as it is the campaign activities.
Right.
And if they're criminally motivated or if there are criminal things happening, actions being done, then maybe that is the only precedent so far is the Nixon case.
Right.
So,
and again, how do you interpret the lack of precedence? I would just say, I try. We have had corrupt administrations,
right? Absolutely.
Grant, Harding, but in neither case does it appear that the presidents themselves, they chose bad advisors.
Right.
They had people who took advantage of the positions, the appointment power that they had. But I can't really think of a president in our history that we believe committed criminal activities while in office.
Right.
And
the other insurrection or rebellion that's been ever alleged in our history was the Civil War.
Well, that's right. Well, you're going to say the only time the U.S. Capitol has ever been invaded, other than 2021, was back in the War of 1812.
Well, there's that. Right. There's that.
By the British.
It wasn't even invaded during the Civil War. Right.
Well, that's right. That's right.
Right. So, of where the seat of government is and what happens to the seat of government. So, yes, they are issues of first impression. I happen to think that once the D.C. Circuit, the Court of Appeals for D.C., finishes its review and makes its decision, I believe the Supreme Court, the U.S. Supreme Court, will take it up. How quickly, I don't know, but I like your idea of, maybe it's not a foregone conclusion that they will. They don't have to accept it just because it's appealed in the proper procedural placement. Doesn't mean they have to accept it.
Can you think historically, is there an issue of that momentousness that the Supreme Court has simply allowed the lower court decision to stand? There surely must be.
There would have to be, but I can't think of one offhand.
That momentous. I mean, you would think, Supreme Court, you would think that they would want to settle this issue. And what would be fascinating is if this course gets to the Supreme Court, if the case gets to the Supreme Court, how will the justices divide?
Right.
Now, the best thing to do, maybe either way, would do a brief per curiam opinion with, basically a statement of fact and one or two reasons, and just leave it at that.
And be done with it. Right.
Right. And, in U.S. versus Nixon, I believe I'm right on this, you had an 8-0 vote. Justice Rehnquist recused because he had been in the Nixon administration, but 3 of the other 8 had been Nixon appointees. And all of them went against the president on the issue of the tapes. Right. And, certainly the court is generally its decisions are thought to have greater weight, often if the Chief Justice writes the opinion.
Sure.
But particularly, and Chief Justices tend to grab, at least the ones where they're in the majority, grab those cases for themselves. But also, the closer they get to unanimity, if it's a 5, and in fact, in the Nixon case, I hate to acknowledge still remembering this, but Nixon had said that he would adhere to a definitive court decision, which many people took to mean if this is a 5-4 or maybe even a 6-3 opinion,
he wouldn't.
Nixon, who, by the way, was an attorney and a fairly accomplished attorney at that, that he might say, well, yeah, 5 justices, but in a matter of this weight, I'm going to respect. I'm a lawyer myself. I'm going to respect the 4 that ruled otherwise. So there would be tremendous pressure. If you're John Roberts, I don't know if you're looking forward to this or dreading it.
Right.
And it's part of what happened with the Dobbs case, right? You
Yes.
end up with a 5-4 decision.
Yes.
And all three of Trump's appointees are on the same side. And
Right.
one of them, at least one of them, was appointed at the last minute.
Right.
So it casts, it makes it no less law of the land, but it makes it less, it makes challenges more likely. If the court's this evenly split on the basic issue, maybe we can, persuade one of the justices to join the other side.
Right. And so they have that possible case coming. They're now getting the appeal from Colorado regarding the 14th Amendment disqualification clause,
Right.
where Colorado Supreme Court says, yes, Trump's disqualified. And now Trump is appealing to the Supreme Court on that issue.
Right. And in the meantime, you have a decision from Michigan, right?
Yes, Michigan.
Okay. In which Michigan says so Colorado has said, although they have not enjoined, what's it called? Stayed
Right.
the order. Colorado has said he can't be on the Republican ballot.
Right. For the primaries.
Right. Primary ballot. Michigan has said, under our state laws, the Secretary of State has no right to interfere at the primary stage.
Right.
So, but part of what's happening here is that the laws of the two states differ.
Yes.
So Colorado and the justices in the Colorado case made a point of saying, we have laws that affect placement on both primary and general election ballots. Not every state does.
Right.
So, and then, this is a question of federalism. Are we as a country, are we okay with allowing some states to include and others to exclude someone from the ballot? Or should there be a single national rule? And again, I don't know. I can make an argument actually for either case, which is why the Supreme Court, they say the cases it gets are all hard, right? Because they wouldn't have gotten to the Supreme Court for the most part unless they were, if it were a simple matter of yay and nay, they just take care of it.
Exactly.
These are consequential issues, and we can only wait with bated breath.
We can
see how the courts might decide.
We've got an interesting year, politically and legally, coming up, and it's hard to pull them apart. They're inextricably intertwined right now. And I believe that, within January through March, we're going to be getting possibly other state decisions with regard to the 14th Amendment.
Next month, early in the year, we get our first caucus.
We do, the Iowa caucus.
In Iowa, shortly followed by, by primaries in New Hampshire and elsewhere. And, I can still remember, and again, I'm going to date myself, but back in 1970, I had my first course in American politics. And I can remember a lecture in which one of an invited lecturer came in and argued that the primary system was not democratic. And what? You're letting the people decide.
Right.
And he made a good argument, which applies, by the way, even more to caucuses, that the individuals who will give up a night of their life to go into an arena and meet with people who have radically different views of your own and sort out who's going to be your nominee.
Right.
God bless them for taking that interest, but they are not necessarily representative of the party as a whole,
right?
Nor are they necessarily representative of the United States voters as a whole. And so, and this happens, by the way, in both parties. Republican activists tend to be much more conservative than the average Republican.
Right.
And Democratic activists tend to be much more liberal than the average Democrat. And so the nomination process, you may win your party's nomination
Right.
and then lose the general election. And this can happen on either side and in either political direction.
Exactly. So, wow. We have all of those coming up. So somehow or another, there will
And a
be
Happy New Year.
decisions. Yes.
And good cheer.
Happy New Year.
To you all.
Peace on earth.
Peace on earth.
Goodwill toward
and by
all.
the way, I didn't get to introduce my weekly wine.
I know. Likewise.
Caffeinated.
Yes.
We are, for reasons that I don't quite understand, we're an all Pepsi campus.
Oh.
They do not prohibit me from bringing
Coke.
other colas on campus, but I cannot purchase anything on campus.
Oh, how
other than
interesting.
Pepsi. And so that is my weekly wine.
Your drink of choice. So my weekly wine, last week we had the wassail and I did it heated. This week, I have done the same Sweetland Cellars spiced wassail. This week, I have done it as they suggested as their alternative measure or means of imbibement is through almost like a sangria. So this week, I have chilled it. And we're going to see if there's much difference between, or which I like. And clearly, there's a difference in hot or cold, but which will be more flavorful or more appealing to my taste buds as to whether it's hot or cold. So cheers for the Legal Weekly Wine. I prefer it cold. I actually prefer it chilled. So that's my taste buds, but it's good. It's New Year. The chilled.
What's the fruit?
That's a good question.
Grapes, I guess.
I mean, well, clearly it would have to be grapes because it's a wine. But the question
But wassails are often ciders, right? So
they're like ciders. They're mostly spices, extra spices involved. So I can definitely taste a lot of cinnamon in there. I believe there is some nutmeg. I could be wrong. And I honestly, I wish it had said more on its labels, but it does not say much more about whether there's, cherry or what else is in there. But it is fairly fragrant. Thankfully, it is not like eating a Christmas tree, which someone warned me it might be. It's not. It's more like drinking a cider.
And how do they know what eating the Christmas tree is like?
That's a good question.
I would check with them. You ever get cereal and you see it looks like needles on the top,
right.
I would be careful.
Well, I do have to say one of the funniest pieces as we end here. My husband loved the pine scents. So you get the sprays, the whatever sprays.
You have one hanging from his car mirror.
Yes, and it was so strong. It really felt like I was eating a Christmas tree. So I had to tell him, I was like, look, we have got to find another scent. It doesn't have to be fruity. It doesn't have to be girly, but it has to be something other than a pine tree. I just can't take it. But as a final announcement for the weekly wine, we are hosted and basically supported by The Law Unscripted. The Law Unscripted is a company. We offer bar review and law exam review classes and the two podcasts. So we have the Legal Weekly Wine and the Law Unscripted podcast. And we support everything about the law and the legal system that you never knew, you never understood, and no one ever told you. So what we're trying to do is take an approach of the, not necessarily just a professor, but practicing attorney and a law student and Dr. Weil, who are putting together a program for the 8 core subjects of the bar that are often done as well during the first year of law exams and law classes. So we've put that together. It is a supplemental course class, exam class, and that is available as we speak. Through thelawunscripted.com, you can find all of those courses there. They're offered individually a la carte. So if you just want a school outline, if you just want a lecture, you can pick and choose as needed. You can get an entire coursework, or you can get the entirety through the All Access Pass. But that is up and running. We're excited about it. We hope that it helps, especially our law students, even some of our undergrad students who are interested in mock trials and evidence classes. And here's to the new year with the full start of the company. So yeah, a pause there, but congrats. And Dr. Weil, thank you for your help and support in there. If you want to get a look at Dr. Weil and I speaking, you can go to the Constitutional Law video reviews in the Law Unscripted series. And that's where Dr. Weil walks us through the entire Constitution from the preamble, not even just Article 1, but the preamble all the way through the 27th Amendment, including case law, which was tremendously done. So if you're looking for more of the constitutional side of it, even those outside of the law schools, that is definitely a good course to take through that walkthrough of how it was created, what it was created to do, and the cases that have continued to define and explain our Constitution and amendments. So thank you, Dr. Weil, and cheers to us, the Legal Weekly Wine, the Law Unscripted, to you, to me, and to the new year.
Happy New Year.
Happy New Year. And
may you not rot in hell.
Yes, may you not. May we find peace on earth. And wishing you such peace and comfort and joy in the new year for yourselves, for our nation, and for the world. Happy New Year, and we'll catch you next time on the Legal Weekly Wine.